SJC-12224, AIDS Support Group of Cape Cod, Inc., v. Town of Barnstable.
Mr. Klein, it's still morning, maybe.
Yes, it is. Good morning, Your Honors, and may it please the Court, Bennett Klein for the Plaintiff Appellant AIDS Support Group of Cape Cod. In 2016, the legislature passed an act relative to HIV and hepatitis C prevention in order to...
2006? Is that what you
I'm sorry,
meant to say?
2006. My apologies. Thank you. In order to expand access to clean needles and address a public health crisis. If the legislature had intended to limit distribution solely to sales by pharmacies and the already existing Department of Health needle exchange programs under Chapter 111, Section 215, then all it had to do was repeal the prohibitions on possession of needles and sale without a prescription. The legislature went much further than this. They repealed the entire statute, Chapter 94C, Section 27, including the existing prohibitions on the delivery and exchange of hypodermic needles.
Do we have any legislative history on this?
There's no legislative history as to why the legislature repealed delivery and exchange but left intact Chapter 111, Section 215. But
So you say that you know that the legislation in 2006 was intended to do as you say, but how do we know that? Does it say so in the legislation itself?
I think it is evident from what the legislature actually did. They had, all of these things were prohibited. Possession, delivery and exchange, sale without a prescription. They repealed all of it. It was a fundamental shift in how the law treated hypodermic needles from a criminalization approach to eliminating these as controlled items. So one of the significant things in how we know what the legislature intended is, in particular, the word exchange. That word was one of the prohibitions in 27B, and it has to have the same meaning as the word exchange in Chapter 111, Section 215. So it was clear from the lifting of the prohibition on exchange that the legislature was intending for people to be able to do what was only permitted for the Department of Public Health prior to 2006. But I think the greatest indication that we have of what the legislature intended is that as a result of these sweeping repeals in 2006, there is no prohibition in the law, either in Chapter 111, Section 215, or 94C, Section 27, on a group such as AIDS Support Group of Cape Cod, a private entity distributing needles. The legislature...
What if 94C, Section 27, instead of saying sold, said sold, distribute, deliver? Would you have a different position?
If they limited distribution only to the Department of Public Health, we would have a different position. But they didn't do that. They eliminated entirely the prohibition on delivery and exchange, which means distribution. They eliminated that entirely, and they left intact only two limitations, which is local approval for the state's own programs and that sales of syringes be only by pharmacists. Now, we know from 94C, Section 27, that they know how to create a limitation when they intend one. They could have said sales, they could have said sales are now, of hypodermic needles are now lawful without a prescription, but they limited it to pharmacists and to people over 18. So they know how to create a limitation when they want to. They didn't create the same limitation.
How do you, though, explain the, and maybe you don't, I mean, it just is peculiar that you have a, you guys can do whatever you want kind of approach, but for the Department of Public Health, 10 pilot programs only with approval by the local town. I mean, they don't seem to go together in that way.
I think there's a reasonable basis for it. for the legislature to treat differently the state's own operated and funded programs. It's reasonable to presume that the legislature, by requiring local approval for state programs, wanted to avoid conflict and friction between the state government and a local municipality. It's also reasonable to presume that the legislature wanted to ensure that when state dollars were being expended, that they were spent in the most beneficial way, which would be where there's cooperation with a local authority, or at least the lack of any opposition. The court doesn't actually need to know the legislature's actual reasons for treating state programs differently, but these are grounds that the legislature could have had to say that that would indicate that there's no basis to ignore the plain meaning of the statute.
Don't we have to find that the two statutes can live in harmony, and that there is plenty of room under your reading of both statutes for a private group to conduct a private needle exchange?
They are in harmony. There's absolutely no conflict between these two statutes. You have one statute that says needles may be sold at a pharmacy without a prescription. You have another statute that says the state may implement needle exchange programs with local approval. Neither statute creates a prohibition, and there is no prohibition in the law on a non-state group or entity. And I think
So can I just ask you a little bit about that? You say there's no prohibition on a non-state entity, how do you get the needles?
well,
So one can go to a pharmacy with a prescription if one is over 18 and get
no,
needles?
without a prescription. You don't need a prescription anymore after the 2006 Act.
All right, so you don't need a prescription. You go to the pharmacy, you can get, if you're over 18, you can get the needles. You can then go out and distribute them to people who are not 18 years old?
Yes,
You can distribute them to anyone.
yes, and the legislature did not put any age limit on distribution. Now, I think it's worth explaining why the legislature did put an age limit, or at least why it's reasonable to believe they put an age limit in the pharmacy commercial context. When you go to a pharmacy, it's a commercial for-profit context. You don't get counseling, you don't get services, you don't get free Narcan, HIV testing, referrals to substance abuse treatment the way you do at a program run by a social services organization. So the fact that the legislature put an age limit in the pharmacy section is indicative of the fact that they did not want minors to get needles where they weren't also getting help for their...
But there's no I mean, I could go out and purchase needles and just stand on a street corner and give them to 3-year-olds if I wanted, right? I mean, there's nothing that requires me to be offering all those other services. I mean, I understand that your
No.
organization does, but
Yes, but I think the legislature, I think, was reasonable in presuming, I mean, who is it that gives out free needles? It's social service agencies that offer people not just clean needles, but offers them help and counseling to deal with their addiction. Notably, it's not reasonable to presume that the legislature wanted to prevent people from getting devastating and deadly diseases by using contaminated needles. The legislature did want minors to have access to clean needles. They just were putting a limit on a commercial context where they weren't getting help. There's no age limit in Chapter 111, Section 215. The fact of the matter is, there is no...
yes, but that's a pilot program. I mean,
Not anymore.
there's
it's
no
not-
requirement that, as I said, there's no requirement that those who give needles do all the services, provide all the services that you do.
Well, yes, but in fact, that is what happens. I mean, people aren't just standing out randomly on the street giving away free needles. Free distribution of needles, and the legislature could have understood this, is done by social service agencies. But I want to make another point here because I think we have to understand the 2006 repeal as essentially eliminating all but two restrictions on everything regarding hypodermic needles. They were dealing with a devastating public health crisis. They removed needles from the definition of drug paraphernalia. They essentially no longer wanted these to be controlled items. And we have to assume, and I think it's a fair reading of the 2006 law, that any person could go to a pharmacy, lawfully purchase needles, and then give them to another person. I mean, that is what the legislature did. They wanted to take this out of the controlled realm because they were decriminalizing to deal with all of this from a health perspective.
Doesn't that argument make Chapter 111, Section 215 superfluous?
It doesn't, because I think it's reasonable to presume that they had a particular interest in the state government not having conflict with a local authority. That's a unique, legitimate governmental interest that doesn't exist in the private context. I mean, the fact of the matter is, the legislature eliminated the prohibitions, and they knew what they were doing. I mean, I don't think it would be fair to ascribe to the legislature that they didn't understand the consequences.
But that didn't work with your client, because I think it was Provincetown that you went through the process. So I don't understand why Section 215 isn't superfluous based on your argument.
I'm not sure I'm understanding your
Well,
point.
with the change of 94C, Section 27, anyone can exchange needles, except if you go into a pharmacy, you have to be 18 and has to be a pharmacist. So why do you need Section 215 anymore?
I think the way to understand Section 215 is to say that the legislature understood that sometimes these programs are controversial. There can be resistance to these programs. There can be a not in my backyard kind of mentality. And with respect to the state governments, they didn't want there to be friction between the state government and a municipality. They didn't want state funds, scarce state public health dollars, spent in a way that wouldn't have maximum benefit because there wasn't cooperation and collaboration with the local authorities. Those unique interests about state-operated programs do not exist in the private context, and so that doesn't make Chapter 111, Section 215 superfluous. They made a policy determination. The legislature made two policy determinations. They repealed everything, every restriction, and they kept two: pharmacy sales over 18 in a commercial context.
So why isn't the concern that you say underlies Section 215 the same with any group, with your group, for instance? I mean, the reason why this case is here is because there's a conflict between your group and the town.
Right.
The town says there are needles all over the place, and we can trace them back to your organization. So why isn't that the same kind of conflict that the legislature was seeking
Well,
to manage under Section 215?
There has been conflict. There has been local resistance to these programs, but the legislature was trying to solve a public health problem. That's why they repealed every prohibition in Chapter 94C, Section 27.
And is that your, I guess I keep coming back to you were so confident about what the legislative purpose was there, and I'm trying to see how you get that confidence about what it was that the legislation was intended to do.
Well, I think
just
it-
reading it from the fact that everything was repealed, therefore, and it was at a time when there was a crisis, so you're superimposing upon the legislation that doesn't itself say this, and there's no legislative history that you're pointing to tell us what the meaning of it is? I'm getting confused as to where it all comes
I
from.
think that, as I said at the beginning, they repealed the existing prohibitions on the delivery and exchange.
And so you're assuming that was done for a particular purpose.
It's hard to imagine what the purpose would have been if all they wanted to do was leave the already existing Department of Public Health programs and pharmacy sales as the sole modes of distribution. They wouldn't have had to repeal those words, delivery and exchange.
What if we cannot ascertain the legislative purpose, or what if we conclude that the legislature did not intend to be permitting the exchange or the giving out free needles to anybody outside of these programs. Does it change your position? Is your position, doesn't matter what they thought they were doing, that's what they did?
Well, I think that this court has been very clear in its case law that the principal insight into legislative intent that Justice Link was inquiring about are the words of the statute. They
Okay, but
did
what if we conclude that's not what they meant to do, but that's what they did?
even if, this court has been clear that even, I don't think it is inadvertent at all. I think it was intentional based on the repeal. But even if it is inadvertent, this court has been very clear that it does not add words to a statute that the legislature didn't put there or rewrite the statute. And I think this.
Don't we look usually at the entire statutory scheme to see what it was? I mean, if we can't tell from looking at a piece of a statute, and we look to the statute and the statutes that really concern the same subject to see what it is that the legislature was intending to do?
Yes, and if you look at the repeal of delivery and exchange and 94C, Section 27 and 111-215, what you see is they repealed everything and kept two restrictions and two restrictions only. And if the court should accept what the legislature did by the repeal and by the words of the statute, which contain no restrictions on distribution, and I've certainly offered a logical reason why the legislature kept the local approval requirements of Chapter 111, Section 215. I don't think there's any basis to say that what the legislature did was irrational, so irrational or illogical that the court should override the plain meaning.
What's the flaw in Judge Mason's decision in Holyoke?
Judge Mason was not addressing the same question here. In that case, the agency, Tapestry Health, wanted to be a Department of Public Health program, and the dispute was around which municipal agency could grant the local approval. He acknowledged in the subsequent orders that we included in the addendum to our reply brief that he was not addressing the question of a non-state program.
Okay, thank you.
Thank you.
So, Mr. McLaughlin, good afternoon.
Good day, Your Honors. The 2006 history on this case was preceded, having in mind, first of all, that 111-215 was adopted first in 1993. There were several attempts to tweak, if you will, the statute, some more substantive than others, predating the 06 legislation in 1990. It's in our brief, 1995, 97, 99, 03, leading to the 06 comprehensive rewrite of the statute. And the reading that my brother applies here, I think, does lead to the disharmony that Justice Gaziano has referred to. If 94C-27 and 111-215 are to be given any meaning at all, and of course we must apply meaning to them, we can't ignore that language. The purpose that the legislature undertook at that time was to make access to needles easier and hopefully to provide needles in ample numbers that would help stem this terrible tide that we're all dealing with.
Can you answer this question? If I went to a local drugstore under your reading of the statute and I bought a case of needles, is it illegal, or does anything prevent me from distributing them to my friends or people I think need them because of a drug addiction?
My reading of that is yes, Your Honor, that the legislature, and this is the point I was about to get to, there were 2 points of distribution. One is obviously the pharmacies, but 2, the legislature thought, I believe in 2006, at least this is a rationalization that I think probably has the most merit, that the 111-215 programs were the appropriate way for folks to gain access to needed needles for whatever purposes.
No matter what increment, if I stood in the street corner, as Justice Botsford had asked earlier, and handed them out, or if I gave them to my brother and said, here's a needle.
As I've argued in...
Have to be registered with DPH?
The answer is no. To be correct in my answer, the answer, I think, is that the legislature expressly contemplated only two methods. One, go to your pharmacist with a prescription, or without a prescription for that matter, and obtain it there. And that is a one-to-one person from the pharmacist to the patron. And two is these programs that are DPH approved.
But what statute has Justice Gaziano in his hypothetical violated?
There is, in the expression of the legislature, I would say that
2005, I violated a statute.
2005, let's keep in mind
The
that
94C
the
statute.
prime intent, I think, in the '06 legislation was to decriminalize. We were filling our jails with very expensive non-treatment programs, but a very expensive opportunity for the Commonwealth to involve itself, or perhaps it shouldn't have been. And I think that was the legislative push at the time, that it was important to decriminalize simple possession.
I got you off the track. You were going to answer the chief's question about
What statute has Justice Gaziano violated in his hypothetical?
In the hypothetical, either 94C-27 or 111-215.
How has he violated 94C-27?
Because the legislature has spoken. The suggestion that my brother has is that when they decriminalized, we left.
Give me some language in 94C-27 that he has violated in that hypothetical.
The legislature was express in its blessing or its pronouncement that there would be two methods of distribution.
Where in 27 does it say that?
In express language, it doesn't.
So how is he supposed to know that he's violated anything?
Because the legislature has expressed itself in saying with specificity that there are two methods of distribution.
Do you think I've violated a crime?
No, no, sir.
I could be prosecuted. Well, 94C is a criminal statute, right?
94C-27
Is a criminal statute.
is now.
Well, it used to be
It used to be
It
criminal.
used to be a criminal statute.
That's exactly the point that I'm trying to point out, Your Honor, is that the legislature carefully contemplated this, and although the type of language that Justice Botsford is asking for is not present in 94C, the legislature was very clear.
Is there a consequence?
Yeah, who can stop me? I
That-
mean, if I,
That's, we've wrestled with that question, I assure you, and it's directly on point. The fact that, as a practical matter, we won't reach into people's homes, we won't know of these transactions, does not mean
I'm
that
on the
that
street
it's-
corner. Who's
that it's
gonna
right
stop
and
me?
defensible. In terms of that, I think the municipality would have the right to seek injunctive relief. If the statutes prescribe two methods of distribution and you have the street corner transaction that we are all concerned about here, that would be legitimized by my brother's argument, and if that's not the legislative intent, and we have an identified distributor of these that is not either a pharmacist or a 111-215 group, I think the municipality would have civil relief, since this is a civil issue, and be able to convince or to bring it to a Superior Court judge for relief.
Injunction would be the only way you could do this?
I think it is.
A permanent injunction?
I-
Based on the fact that this is a violation of a statute that doesn't expressly say that this isn't a violation?
I'm not sure, I don't,
Get injunctive relief that way?
where's the clear and unequivocal command that I'm?
That's a fair question, and I believe that the legislature, in decriminalizing, wanted, and perhaps with less a degree of articulation than it should have, posited that there are two ways that you can now obtain drugs, one through the pharmacy and one through needle exchange programs. And so-
Let me ask you this. So both of these statutes, neither of them are ambiguous. Would you agree? They're pretty straightforward, right?
I think they are.
So on what basis do we start trying to find some interpretation along the lines that you're suggesting?
In decriminalizing, the legislature in a 17-section statute addressed a whole series of issues, and the ultimate goal, of course, was to decriminalize. The related portion of the specific language that the legislature employed was to allow two methods of distribution, and I think that's all that they accomplished. Could they have done perhaps a better job? My brother included in his addendum some language that was floated through the legislature this past July from the representative from Barnstable that might have helped clarify this issue.
So isn't this, I mean, basically what you're saying, it sounds like this is for the legislature to sort out.
That's ultimately where we suggest this go. But the question is, to what point? The concern we have, and I just want to go back to the issue of disharmony that was mentioned earlier, why I think both 27 and 215 have the weight that they have is that if they are ignored, and my brother's supposition that anyone can distribute needles and syringes to anyone of any age at any place without restriction, means that we have to ignore the language of 27 and 115 to 111, 215.
How do you have to ignore, put 215 aside for a minute. What part of 27 are you ignoring by saying that?
I should also mention, Your Honor, and I neglected to earlier, that interestingly, the Department of Public Health and we cite under 105 CMR 105 itself, it actually says that a pharmacist can lose their license for a violation of 94C. 94C obviously
I understand a
includes
pharmacist,
27.
but I'm not a pharmacist. What am I violating? I'm still confused.
What I wish the court to go away with is the proposition that there are only, the legislature intended only two methods of distribution, and if you aren't protected by those areas, you are not entitled to be distributing.
I don't want to oversimplify it, but aren't you saying that if 94C Section 27 is going to be the law, then based on that interpretation from the opposing counsel, what's the point of having Section 215? There's no point in having it.
I think both, and I was going to comment on your superfluous observation earlier, and to add, I think my brother's argument means that both 94C 27 and 115, 215 rather, become superfluous if my brother's argument is adopted, that there's no restriction whatsoever. If there is no restriction, why have those two sections? Right. If we're going to give meaning to those two sections, albeit perhaps less fully developed than we might have wished, there seemed to be, to this officer of the court, a limited methodology for distribution, and if you're
Why
not
would the
protected in that area...
legislature have repealed the section of 94C prohibiting the possession of hypodermic needles if what you say is what they intended? What would be the purpose of that?
Of decriminalization?
Yeah.
I think the primary concern was that we were putting two reasons. One is that we were putting people in jail simply for possession and distribution, and that was, in many instances, putting people in jail who really needed medical help, number one. So why make it a crime and why fill our jails? But the second reason...
That answers the question. I mean, if they didn't want people to be jailed for possession, then it follows that the statute should be interpreted that wouldn't happen, that anybody who wanted to can possess and do whatever they want except sell it.
In the 2006 legislation, the legislature expressly referenced under Section 15, 111-215, and endorsed it yet again, as they have done repeatedly as recently as this past July when they addressed it. And that, I think, in terms of, as we attempt to determine what legislative intent was, I invite the court's attention to the 2016 legislation that, again, took away all caps, and made this the preferred choice statewide, that if you're going to be distributing needles in volume, and it should be as part of a program that obviously, as these good folks have, folks who are dedicated, who are knowledgeable and responsible, and the legislature wished to see that type of program furthered. That goes back to the 2006 intent. Why have 10 programs? We want 10 programs because we want that type of professional involvement, concerned and knowledgeable involvement, and that 215 therefore is, I think, a very good guide as to what the court's intent, strike out what the legislature's intent was at that time.
What do you make of the more fundamental sort of statutory construction, canons of construction here, which seem to be you're both agreeing that the statutes are unambiguous, but you think they mean different things because you think that, I think that the plaintiff's position is what is not prohibited is not prohibited. What is not expressly prohibited is not prohibited at all, and you say it's impliedly prohibited. Is what I understand.
It's impliedly prohibited based on the statutes, but also the agency that has the most knowledge of that, the Department of Public Health, has a regulation, CMR regulation in place that says, at least with respect to 94C27.
But it's only as good as the statute. The regulation's only as powerful as the statute.
I understand, but the agency charged with interpreting it can, if you will, disbar or remove a licensure of the pharmacist who violates that statute.
Back to the
Who
Chief
sells to
Justice.
someone who's 15.
I'm sorry, Your Honor.
The CMR would prohibit that what the statute prohibits. So the CMR would say, if you're a pharmacist and you distributed a needle to someone who is 15, you can be debarred.
That is correct.
That's as far as it goes.
That is correct. I don't disagree with that.
Can we go back to Chief Justice Gantz's question? So what if in Chapter 94C, Section 27, the legislature, when they said sold, what they really meant was to say distribute, but they said sold? What are we supposed to do?
That's been one of the issues of this case, and interestingly, as we note in the brief, the Department of Public Health in its 700-108 puts "to sell" in quotes, and as we have pointed out, that's apparently the only place we can find in the CMRs where something like that has been put in quotes. I think it's a recognition that perhaps "sell" was a poor choice of words. I think, frankly, they may have had a far broader intent, but understanding the rules of interpretation, we have to give that, in all probability, meaning, even though the Department of Health seems to put that in question. So I would say at the end of the day that the distribution without compensation is handled by 111-215. It's also, there's nothing prohibiting a pharmacy from distributing without charge, should they wish to do that. And so I think those remain the two methods of distribution here. And to suggest to my brother's analysis that the unlimited distribution by anyone at any time would mean that the pharmacist can lose his license for a distribution that violates 94C27, while the street corner distribution to, as Justice Botsford said, a 3-year-old goes scot-free. I can't believe that that would be in the public interest and really what the legislature had intended at the time.
Okay, thank you.
Thank you.